Thank you for giving me the opportunity to speak about Jim Madison. I was honored last year to be the first inductee in the CLA ADR Hall of Fame. And I'm delighted that my old friend Jim Madison will join me this year. Jim is an ADR pioneer. He was a leading arbitrator when I began to work in the field in the early 1990s, long associated with the American Arbitration Association and a leader in many dispute resolution organizations. Jim knows more about arbitration than almost anyone and is willing to share his knowledge with anyone who cares to listen. I most admire Jim's strongly held views on most everything, and it's more fun to discuss and argue with him than almost anyone. When we explored the creation of the College of Commercial Arbitrators in the late 1990s, Jim was among the first Californians I invited to join. He became a founding board member, and he has been an enthusiastic fellow to this day. I applaud the California Lawyers Association for the choice of Jim for this honor, which is richly deserved.
I'm Ruth Glick, and Jim, I'm so pleased that you are ADR Hall of Fame honoree. You've been one of the pioneers in the development of our profession in California and beyond. I remember meeting you, must have been at least 30 years ago at some of our burgeoning professional organizations like the California Dispute Resolution Council, of which you were president, the Mediation Society of San Francisco, in which you served on the board, San Francisco Bar Association, San Mateo Bar Association, where you had leadership roles, and of course, as one of the founding members and board members of the College of Commercial Arbitrators. What many people don't know is about that time you were driving a car with a license plate coach to commemorate your role as a youth soccer coach. But coach is what you've been to so many of us in the ADR community. When interesting issues arise in law or the practice of arbitration and mediation, you've coached us to find a common sense approach to dealing with it in our law practice. And when lawyers post some on their listserv to arbitrators and mediators, some of the problems of complicated concerns and issues that arise, you can define the problem in just a few sentences and predict how things will turn out. And you know what? You're usually right. We're thankful to you and Paul Dubois, our other exceptional honoree, for the tireless work you both do throughout the year in presenting new case law and legislation concerning arbitration and mediation. You and Paul selflessly prepare a synopsis of noteworthy California and federal case law and present it to numerous groups so we can all effortlessly keep up with the changing law in our field. Jim, you have not only been coaching as an ADR in your capacity as a law professor and experienced practitioner, but you've always been most gracious with your time to young and up and coming lawyers. But most importantly, you and Paul have, throughout the years, spent a lot of time coaching our legislators in Sacramento and teaching them the difference between mediation and arbitration, among other things. So, Coach, thank you. You've been a role model for excellence in the profession and most worthy to receive this ADR Hall of Fame award. Congratulations.
Morning. I met Jim Madison back in 2008 or 2009 when I decided to focus my practice on being an arbitrator, not trial work. And of course, like all of you, I'm one of the great beneficiaries of the Jim and Paul Dubois annual review of California law, of Jim's always thoughtful comments on arbitration, of his help, of his friendship. But for today, I want to just talk about one thing, an article that he mentioned to me that I might want to read on review of legal errors. It's in 21 Golden Gate Law Review 245, a 1991 piece, so before Armendariz, before the Supreme Court Hall Street case. And there are two things that just struck me about that article when I read it then and last night when I reread it this brilliant piece. One is that he frames a very, very complex issue in a very, very clear, simple way. So right at the outset, he talks about the problem of arbitrators being able to do equity, and therefore, how can you review what they do? The limited occasions where the Supreme Court has intervened on legal errors, that the Court of Appeals often ignores Supreme Court decisions, the manifest disregard doctrine, the old error on the face of the award excuse for reviewing, and the problem of agreements to allow review and whether agreeing to California law is such an agreement. But then I just want to read you the sheer beauty of 4 or 5 of his topic sentences and one sentence that's about the 1991 case that caused him to write the article and that he goes at. Here are the topic sentences. Another nail in the coffin of reviewability of legal error was driven by the Supreme Court in O'Malley v. Petroleum. You just want to read on, don't you? If the Supreme Court thought, again, topic sentence, start of a paragraph, very simple. If the Supreme Court thought that by SAP, it was creating an Eden of non-reviewability, the ink was scarcely dry on the opinion before the serpent began lurking about. Another topic sentence. Still others, other courts, simply ignored the Supreme Court. Another topic sentence. The fun really began with Allen. And then here's the summing up critical analysis of this recent 1991 decision he's talking about in a 1991 article. One wonders why the PG&E court expounded to the extent it did to reach this limited conclusion. It appears merely to revise the vocabulary used by previous courts without altering in any substantive way the willingness to review awards for error of law. I wish, Jim, that I could write that well. We're all your students and we're all in your debt. Thank you very much.
Hello, everyone. My name is Ed Lozowicki. I'm a arbitrator and a former business trial lawyer. I've known Jim Madison for about 40 years, both as a colleague in the arbitration world and a friend. It's a pleasure to join you all in honoring him on this event. There's a time-tested phrase for special people, which I'm sure everybody has heard in the past, a gentleman and a scholar. That truly describes Jim Madison. Most of us know about his encyclopedic knowledge of arbitration law, which he updates from year to year and shares with us at ABA meetings and CLA meetings. But he's also a gentleman. And by that, I mean, he is cordial, he is friendly. I've never heard him say a nasty word about anyone. A pleasure to work with, a true gentleman. So it's he also has a sense of humor. So it's a pleasure to congratulate him for being inducted into the ADR Hall of Fame, and I wish him best of luck. Thank you.
Hello, I'm Tom Reese, a civil litigator out of Palo Alto. I've known Jim ever since I left my firm from civil litigation to go into ADR practice. Jim did approximately the same thing, and this was about 25 years ago. I have served with Jim on just about every ADR, that's alternative dispute resolution, committee, either through the Bar Association or other outfits. I believe my most outstanding memory or impression of Jim is that he is a digger. He's a digger for all relevant facts, all relevant statutes, cases. He just doesn't stop at the initial impression. In other words, I would regard Jim as a very inquisitive very inquisitive jurist. He is by no means a flyover type of arbitrator or dispute resolution person. I think he is probably best known for this distinctive attribute. And I would present any dispute to him, knowing that it would be thoroughly reviewed. So good luck, Jim, and congratulations.
Good day. My name is Richard Flyer. I'm the president of the California Dispute Resolution Council, or CDRC. I'm here to applaud your selection of James Madison for the California Lawyers ADR Hall of Fame. Indeed, after 60 years as an attorney, 35 years as an arbitrator, and 15 years as a mediator, it's about time that Jim is recognized for his many ADR contributions. He once humbly said, "Although I specialize in construction and employment disputes, I am also experienced," and here he mentioned over a dozen other areas. He actually has specialized experience in over 58 separate fields of law, literally from A, agriculture, to W, wage and hour disputes, and everything in between, including things like vegetable seed breeding, biotechnology, and medical billing, just to name a few. He is licensed before 8 separate courts, including the US Supreme Court, and 10 bar associations and professional affiliations, including such disparate groups as the American Society of Civil Engineers, Mediation Society, for which he is on the board of directors, and CDRC, which is a lobbyist organization. Jim is a past president of that organization, CDRC, and has been the author of amicus briefs on CDRC's behalf to numerous appellate courts. He has regularly shared his experience and knowledge as a teacher and author. Jim annually presents ADR case updates with Paul DeVoe to the Bar Association of San Francisco, the AAA, the San Francisco Bar, the CLA, the CCA, and the Mediation Society. He is one of the contributors of the College of Commercial Arbitrators Guide to Best Practices in Commercial Arbitration. He served on the Judicial Council Committee that drafted the Arbitrator Code of Ethics. In my work with Jim, he is the perfect diplomat and statesman. He understands the intricacies of situations. He makes sage observations. His experience and wisdom provide exceptional guidance regarding the politics and reality of ADR law. Through it all, he is always of good humor and a willing volunteer. As an attorney, neutral, and teacher, Jim Madison has been providing quality work and service in the ADR community for generations. It is only fitting that we recognize this all-star in the Hall of Fame. He is a model for each of us. I commend the California lawyers once again for its selection, and I congratulate Jim Madison for this well-deserved recognition. In all sincerity, it has been an honor and a privilege to know and work with this man. Thank you for giving me this opportunity to make this introduction.
Congratulations, Jim. I was so pleased to see that you are going to be a member of the ADR Hall of Fame. Very well deserved. I've seen you make so many contributions to nurturing and improving ADR over the years, and I know we all appreciate it. You were there in the 1990s when many of us who were starting to do arbitrations were meeting periodically to talk about the process and how we could do better and establish some best practices. And of course, you've been a member of the College of Commercial Arbitrators and have made numerous contributions to all of us in our understanding during the time that we've all been in the college. Way back, I always enjoyed speaking with you on ADR topics, which we did a few times in various conferences. You were so good at updating all of us on evolving ADR law and giving us the latest and greatest. So you've been a friend and a mentor to many of us, and we're very appreciative of it. Thank you so much, and congratulations.
Hi, Jim. It's Michael Powell here in Los Angeles, reaching out to you in tribute to your recognition of being inducted into the California Lawyers Association Hall of Fame. You are a true pioneer in ADR, and I am honored to know you and to have worked with you. For 61 years, you have been a part of the American Arbitration Association family, lending your knowledge and common sense approach to arbitrations and giving back by teaching and training aspiring and veteran arbitrators. You know, Jim, I've been with the AAA for 29 years, and I owe my longevity and passion for this field to you, Jim. I also want to mention your dedication to the California Dispute Resolution Council, the voice of ADR in California. This is another area you have made tremendous strides, speaking to legislators and fighting the fight to ensure access to justice for everyone. I owe my career and all the fond memories to you and the others that stand by your side. Be well, my friend, and again, my most cheerful congratulations to you.